Good evening, ladies and gentlemen. I'm Driti Atri, and once again, you're watching Skyline. Money, immigration, wars, visas, taxes, and jobs. At first, all of this, it may sound complete different, but if you look closely, they are all connected. A new law passed in Delhi, it can change the future of an entire Indian family living in California. A policy announced in London, it can affect a student from Hyderabad, India. A visa rule in Washington, it can decide whether a software engineer keeps his job or packs his bag. These are not just headlines, these are decisions that could change careers, investment, and even people's future. So stay with me till the very end because every single story tonight, it is built on the previous one. So let's start with it. For years, millions of Indians working in the United States, the United Kingdom, Canada, and Australia have been sending money back home. Some buy homes, some support their parents, others invest in mutual funds and shares. But many wealthy Indians had one common complaint. They wanted to invest more in India's fastest growing companies, but the rules simply didn't allow them to. Well, that is now changing. Very quietly without much noise, but the impact, it could be massive. The government of India has made an important change under the Foreign Exchange Management Regulation. Earlier, an individual NRI could only own up to about 5% of a listed Indian company through the Portfolio Investment Scheme. Now that particular limit, it has been doubled to 10%. At the same time, the total investment limit for all overseas investors in one listed company has increased from 10% to 24%. It may sound just another policy update to you, but for thousands of overseas Indians, this is a major opportunity that could completely change how they invest in India's future. Now, you may ask, why is this such a big deal? It is because many overseas Indians have been waiting for exactly this moment. Earlier, whenever foreign investors reached the investment limit in a company, banks automatically stopped new purchases. Even if you had money already, even if you believed in that company's future, you simply couldn't invest. The system itself, it blocked you. The opportunity was there, but the rules stood in your way. Today, that door, it has become much wider, giving NRIs far greater freedom to participate in India's growing economy. Think about India's economy today. AI, defense manufacturing, electronics, renewable energy, railways, infrastructure, semiconductor production. India is becoming one of the fastest growing major economies in the world. Global companies are investing billions of dollars over here. New factories are opening. Startups are becoming global brands. Many NRIs don't just want to send money home anymore. They want to become investors in India's success story. They want their savings to grow alongside India's growth, and now, for many of them, that has become much easier. But yes, here's where many people make a mistake. They hear the word investment opportunity and they immediately rush to open the trading account or buy the shares. Investing is important, I do agree, but following the rules is even more important. Every country has its own financial regulations, and NRIs have to follow the laws of both the nations that they live in and the nation where they invest. Well, let me give you an example here. If you live in the US, your Indian demat account, your NRI account, or your NRO account may also fall under American Foreign Financial Reporting Rule. Buying shares is only part of the process. You may also have to report these investments correctly while filing your taxes in the US. Missing these requirements can create unnecessary legal and financial problem for you later on. Ladies and gentlemen, this is the new reality for global Indians. Your salary may come from California, your investment may come from Mumbai. Your taxes may be filed in New York. Your family may live in Bengaluru. One financial decision can involve multiple nations, multiple regulations, and multiple reporting requirements. And that is why overseas Indians today, they need to think far beyond simply earning money. They need to understand how global finance actually works. Well, the government's decision has undoubtedly opened a much bigger investment window for NRIs. But the opportunities bring responsibilities. Well, those who do understand the rules, plan carefully, and invest wisely are likely to benefit the most. Because in today's connected world, building a wealth that is not only about how much you earn, it is about how smartly you manage every opportunity that comes your way. Now, let's shift to the United Kingdom because for thousands of Indian students and young professionals in the United Kingdom, getting a graduate visa after completing their studies it is seen as the beginning of a new life. It gives them the opportunity to work, gain international experience, and build a career. Well, many even decide to settle down there, get married, and start a family. But very few knew that until now, having a baby in the UK, it could unexpectedly create a serious immigration problem. It sounds unbelievable, but for hundreds of families, this was a very real legal challenge. Wait, here's what happened. Under the earlier immigration rule, international students could switch from a student visa to a graduate route after completing their studies. However, if they had a baby after moving on to the graduate visa, there was no proper immigration pathway for that child under the existing rule. Many parents naturally believe that because their baby was born in the UK, everything would automatically be taken care of. But here is the reality that does not happen. A child born in the UK does not automatically become a British citizen simply because they are born there. Well, for temporary visa holders, immigration status that still has to be secured through the correct legal process. Now, this created a lot of confusion. Parents, they had legal permission to stay in Britain, but their newborn child often did not have a straightforward route to obtain the same status. Families were forced to depend on complicated applications, expensive legal advice to an uncertain immigration decision. Many lived with constant anxiety, wondering whether a simple paperwork it could affect their child's future in the country where they are born. Wait, the good news is that the UK government has finally stepped in to fix that loophole. Under the latest immigration changes effective from August 3rd, 2026, a child born in the UK, while at least one parent hold a valid graduate route visa, can now apply for dependent status from within the UK itself. Once it is approved, the child's visa it will remain valid until the parent's graduate visa expires. It may sound like a small administrative update for you, but let me tell you, for hundreds of Indian families, it removes months of uncertainty and provides much needed legal clarity here. However, there are still important conditions that parents cannot ignore. This rule is not an expansion of a graduate visa scheme. It does not allow families to bring dependents from overseas under new rule. It only solves the problem for children that are born inside the UK. Parents must also ensure that the application for their newborn is submitted while they are still in the UK. If they leave the country before completing this process, they may lose access to the simpler route and they have to go through the complicated immigration procedure later on. Well, there is also the financial aspect here. Parents will still have to pay required visa application fee and the immigration health surcharge for their child. So, while the legal pathway has become much clearer, the overall cost of maintaining the immigration status that remains significant. Anyone who's planning to build a long-term future in Britain must continue budgeting for these immigration expenses well in advance. Ladies and gentlemen, the larger message is simple here. Immigration rules are constantly changing and even small policy update can have huge impact on the families. What may look like just another government notification, it can completely change the future of parents raising their children abroad. For Indian students and professionals in the UK, this correction it removes one major source of uncertainty and ensures that newborn children are no longer caught in an unnecessary legal grey area. Let's shift back to the NRI section tonight. If you are an NRI who studied, worked or lived abroad, there is a good chance that you still have a foreign bank account, an old investment account, or perhaps some company shares that you never closed before running to India. Maybe you thought that they were too small to matter. Maybe you simply forgot about them. But for years, even a small mistake like this it could create a massive legal problem under India's tax laws. A forgotten overseas account, it could attract heavy penalties and, in some cases, even the possibility of criminal prosecution. That fear has worried thousands of returning Indians for years. But now the government has finally decided to change that. Now wait, to understand why this announcement is so important, we need to look at the old system here. Under the Black Money Act, anyone who became an Indian tax resident had to declare their foreign assets while filing their income tax return. It didn't matter whether the account had a huge balance or just a small amount of money. Even if somebody had forgotten about an old saving account opened while studying abroad, failing to report it, it could lead to severe penalties. Many returning professionals from countries like the US, Canada, the UK, Australia constantly worried that a simple oversight, it could become a legal nightmare for them. And now comes the big relief here. The government of India has introduced an important amendment that offers protection for small foreign assets. Under the new rule, ladies and gentlemen, if the total value of your non-immovable foreign asset is below 20 lakh rupees, you will no longer face criminal prosecution under the Black Money Act for not reporting them. This is a major shift. Why? Because in the government's approach, it is different. Instead of treating every reporting mistake as a criminal offense, the focus is now moving towards encouraging voluntary compliance and giving honest taxpayers a second chance. Even more importantly here, this protection has been made effective from October 1st, 2024, offering relief for many cases here. But what if your foreign assets are worth more than 20 lakhs? Well, the government has an answer for that too. It introduced a special disclosure program called FAST DS 2026, giving taxpayers a limited opportunity to voluntarily declare certain undisclosed foreign assets here. Depending on how these assets were acquired, taxpayers can regularize them by paying the required tax or prescribed fee. The idea is very simple here. Come forward voluntarily now instead of facing much bigger legal consequences later. This policy change, it comes at a time when government across the globe, they are sharing financial information more closely than ever before. Countries now exchange banking and tax information through international agreements, making it much easier for the authorities to identify undeclared foreign assets. In other words, hiding overseas assets has become far more difficult than it was a decade ago. What remained invisible in the past, it can now be traced through international financial reporting system. Well, for overseas Indians and returning professionals, the message is kind of clear here. This is not an invitation to ignore tax rule. It is an opportunity to correct old mistakes before they become bigger problems. Anybody holding foreign accounts, overseas investment, or doormat financial assets, they should carefully review their financial record, understand their reporting obligations, and seek professional advice if it is required. Waiting until a tax notice arrives, it is not a good strategy for sure. Well, the government's decision reflects a broader shift in India's tax policy. Instead of focusing only on punishment here, the authorities are trying to build a system that encourages voluntary disclosure and honest compliance. For millions of Indians who have lived abroad, this could bring much needed peace of mind for you. But that peace of mind, it will only come to those who use this opportunity and ensure that all their financial information is properly disclosed going forward. Now, let's move to the US policies that is shaking up the H-1B employees, because for thousands of Indian professionals working in the United States, an H-1B visa, it is much more than a work permit, right? It is the foundation of their entire life in America. It decides whether they can work, whether they can stay in the country, and for many, whether they can one day become permanent residents. Most H-1B workers, they focus on doing their jobs really well and assume that their employer is taking care of all the paperwork. But what if the biggest risk right now to your visa, it is not your performance? What if it is your employer's paperwork? Well, that's exactly what American authorities are now forcing on. The US Department of Labor has significantly increased enforcement under an initiative known as Project Firewall. The goal is to ensure that companies hiring foreign workers are following every single rule laid down under the H-1B program. Authorities are no longer treating visa paperwork as a simple administrative formality here. They are carefully checking whether employers are paying the correct wages, whether maintaining proper records, and following all legal requirements while hiring foreign workers. In fact, one of the most important documents in H-1B process is called the Labor Condition Application or LCA. Before an employer can sponsor an H-1B worker, they must submit his document to the Department of Labor. Now, through this particular application, the employer makes several legal promises. Well, they must confirm that the foreign employee will receive at least the prevailing wage for that particular job. Well, they must certify that hiring an H-1B worker will not negatively affect the American workers. They must also publicly notify employees at the workplace that an H-1B application has been filed. Well, these are not optional formalities anymore. These are legal obligations. Earlier, many companies treated these requirements as routine paperwork. But that approach, it is no longer acceptable. Well, under the latest enforcement drive, even small compliance failure, it can trigger detailed federal investigation. If an employer submits incorrect wage information, fails to display the required public notices, or does not maintain proper documentation, then the Department of Labor can launch a formal audit. That audit may lead to heavy financial penalties, back pay orders as well, and even restrictions on the company's ability to sponsor foreign workers in the near future. Well, there is an important development here that can directly affect the H-1B salaries. The Department of Labor has proposed increasing prevailing wage level across different job categories. If implemented, then companies may have to pay significantly higher salaries to sponsored foreign workers in order to maintain compliance with federal regulations. Well, for the employers, this means higher hiring costs. Well, for skilled professionals, it may create better salary opportunity, but it also can make companies more cautious while hiring a new H-1B employee. So, what should an H-1B worker do? First of all, understand that your immigration status, it depends not only on your own action but also your employer's compliance. Ask questions if it is necessary. Ensure that your employer follows all the rules. Make sure your salary matches what has been officially filed, and keep the copies of important immigrant documents and stay informed about any policy changes that could affect your status. Being aware today can help prevent major problems tomorrow. The larger message is simple here. The US is not ending the H-1B program, but it is making it very clear that companies must strictly follow every rule. Honest employers have nothing to fear, but companies that cut the corners or maybe ignore compliance requirement may soon find themselves under intense government scrutiny. And unfortunately, when employers make mistakes here, it is often the employees who suffer the most. Well, if you are working in the United States on an H-1B visa, there is one question that you should ask yourself today. How well do you really know your employer? Most people carefully read these salary packages, job titles, and office location before accepting an offer. But you know what? Very few check whether the company sponsoring their visa has a clean legal record or not. And that particular mistake could prove extremely costly because the US government has now taken strict action against several employers accused of violating the H-1B rules. The US Department of Labor has updated its official list of employers that have been debarred from the H-1B program. Let me simplify this for you. These companies have been barred from sponsoring a new H-1B worker because authorities found serious violation of labor and immigration law. Well, this is one of the strongest action the government has taken against an employer under the H-1B system here. Ladies and gentlemen, according to the latest update, 4 companies have been placed on this particular debarment list here. They include Goratech, Renotech, Silos, and Sherwood at Mount Dara, operating as Sherwood Academy now. While these companies have been prohibited from filing new H-1B petition for waiting period after federal authorities found significant compliance failure. Now, here's a question many Indians are asking. What happens if you already work for one of these companies? So, the answer is very important. Your H-1B visa does not automatically becomes invalid overnight. However, your future immigration journey, it can become much more difficult. Well, a debarred employer cannot file an H-1B extension when your current visa expires. It cannot sponsor changes to your employment. It also cannot move forward with certain employment-based immigration processes, including the future green card sponsorship in many cases. So that means an employee who has done absolutely nothing wrong may suddenly find themselves in a difficult position simply because their employer failed to follow the rule. Can you imagine working hard for years, building your career, paying the taxes, and following every immigration rule, only to discover that your company's legal problems are now affecting your own future? Well, it is a situation no professional wants to face these days. Well, the government's message is becoming increasingly clear. Companies hiring foreign workers are expected to follow every requirement under the H-1B program. If they fail to pay proper wages, submit incorrect information, or violate labor regulations, they can lose the privilege of sponsoring foreign talent. American authorities are making it clear that immigration compliance is no longer something companies can take lightly. So, you know what an H-1B worker should do? The first step is awareness. Before joining a new employer, verify its reputation and compliance history. If you're planning an H-1B transfer, make sure the sponsoring company is eligible to file your petition. A good salary and an attractive job title, it means very little if the employer cannot legally support your immigration status in near future. Well, this development also highlights much bigger trend here. The US is not simply checking visa applications anymore. It is also carefully examining the companies that bring the foreign talent into the country. Employers are now under the microscope just as much as employees are. And as enforcement becomes stricter, choosing the right employer, it may also become just as important as getting an H-1B visa itself. Well, for decades, thousands of highly skilled Indians have followed the same path. They studied hard, got a job in America's biggest tech companies, paid all the taxes, bought homes, and built families. They believed that if they worked honestly and followed every immigration rule, one day they would receive the green card. But for many, that day never came. Instead, they found themselves trapped in an immigration system where they kept on waiting longer and longer. Some have already spent more than a decade waiting. Others fear that they may have to wait even longer. You know, the biggest reason behind this problem is America's employment-based green card backlog. Under the current system, every country is subjected to annual limit on employment-based green cards. Since India sends a large number of highly skilled professionals to the US every year, thousands of Indian applicants end up waiting in extremely long queues. Even after getting an approved employer sponsorship, many employees, they continue renewing their H-1B visas year after year before their green card simply does not arrive. Now, a new proposal introduced in the US House of Representatives is giving many families fresh hope. That's right, lawmakers have proposed updating a little-known part of the Immigration and Nationality Act called Registry Provision. Under the current law, this provision applies only to the people who have been continuously present in the US since January 1st, 1972. Now, as you can imagine, that date, it makes the law almost meaningless for today's immigrants because it excludes nearly everybody that is currently living and working in America. Well, the proposed legislation, it wants to change that completely. Instead of using a fixed date from more than 50 years ago, lawmakers are suggesting a rolling 7-year rule. In simple words, people who have maintained continuous legal physical presence in the US for at least 7 years, they could potentially become eligible to apply for PR under the updated registry system. If such a proposal ever becomes a law, then it could completely reshape the future of thousands of long-term immigrants who have spent years contributing to the American economy. Well, for Indians, the complication, it could be a lot. Many professionals have spent years working in Silicon Valley, Seattle, Texas, and other tech hubs while maintaining dependent on employer-sponsored visa. Every time they change the job, they worry about the paperwork. Every time layoffs happen, they fear losing their legal status. Every visa extension brings fresh uncertainty. Well, a simpler pathway to permanent residency, it would remove much of this anxiety and give the families a greater stability. This proposal, it could also bring relief to another group that has received increasing attention in recent years: documented dreamers. Well, these are children who legally entered the US with their parents on dependent visas but risk losing their immigration status when they turn 21 because they age out of the whole system before their families receive PR. Many of these young adults, they have grown up in the US, attended American schools, and they don't know anything of Indian culture. Supporters believe that immigration reforms should also provide certainty to these families. However, before anybody celebrates, there is an important reality that cannot be ignored, that this is only a proposed bill. It has not become a law. It must pass through the House of Representatives, the Senate, and finally receive the President's approval before any changes can take the effect. In Washington, many immigration bills are introduced every year, but only a small number successfully complete this long legislative journey. So, what should Indians do today? Here the answer is simple: stay informed, but don't make life decisions based on proposals alone. Continue maintaining your legal immigration status, keep your documentations updated, and closely follow all the legislative developments. Immigration reforms often take time, and until a bill becomes a law, existing rules remain in place. So the bigger picture is this: the fact that lawmakers are discussing such a proposal shows that the green card backlogs have become impossible to ignore. The pressure for reform, it is growing because businesses, universities, and immigrant communities all recognize that the current system is struggling to meet today's reality. Whether this proposal succeeds or not, one thing is definitely clear: the debate over America's immigration system, that is far from over. For years, people applying for asylum in the US knew that there was one important step in the whole process. Before their case reached an immigration judge, they would first sit down with the USCIS asylum officer for an interview. It was their first opportunity to explain why they feared returning to their home country. Now, that interview became one of the most important parts of their entire process. But now that long-standing system has changed, and the impact could be felt hundreds of thousands of people navigating the US immigration system. Ladies and gentlemen, the US Department of Homeland Security has introduced a new interim rule that changes the US Citizenship and Immigration Service, while here greater flexibility in handling the asylum application. Under this policy, asylum officers can now, in certain cases, send applicants directly to immigration court without first conducting the traditional in-person asylum interview. In simple words, some applicants, they may now have to move straight to formal investigation court proceeding much earlier than before. And you know why the government has changed that? The answer lies in one word: backlog. US immigration system is carrying a lot of numbers of pending asylum cases. Millions of applications have built up over the year, creating long waiting period for both applicant and immigration authority. The government here says that the new rule is designed to reduce these delays, speed up the cases, and help clear the growing backlog that has overwhelmed the immigration system. However, critics argue that while faster processing, it may reduce the delay, it could also make the system much more challenging for applicants. Earlier, people had the opportunity to explain their case in a relatively less formal interview with a trained asylum officer. Now, if some cases move directly to immigration court, then applicants may have to present their argument before an immigration judge much sooner, often in a far more formal legal environment. Well, for many people, that could mean preparing for the court much earlier than they are expected to. And yes, another important issue is work authorization. Many asylum applicants receive permission to work in the US while their cases remain pending. If cases move through the whole system very quickly, then final decision, it could also arrive sooner. For applicants whose claims are approved, That may bring faster clarity. But for those applicants who are denied, it could also mean facing removal proceeding much earlier than under the previous rule. And that is why government lawyers are urging all the applicants to ensure every document it is completed and every legal deadline is carefully followed. For Indians, asylum is not the route chosen by most of the legal immigrants. The majority of Indians move to the US through the employment visa, student visa, or family-based immigration. However, this whole policy change, it still matters because it reflects a much broader trend in the US immigration enforcement. Well, the government is focused on processing cases faster, reducing administrative delays, and moving people through the system more quickly than before. And with that, we have reached the end of tonight's Skyline. At first, these may look 7 separate stories, but together they tell you one bigger story. Governments across the globe are rewriting immigration, investment, and tax rules faster than ever before. For overseas Indians, staying informed, it is no longer just helpful, but it has become essential. One new policy can affect your visa, your job, your investment, and even your family's future. I'm Driti Atri. Thank you for watching Skyline. Stay informed, stay aware, and I will see you in next episode.